the class. All right, just so you guys know, we are recording. So for the most part, I think we have figured out how to upload the video without capturing everybody's name, right? Okay, so if you talk, it can show your picture unless you turn the picture off, but I really like to see your guys' faces because it makes it feel like I'm talking to other men and women instead of just a computer screen. So what we're going to do tonight is we're going to go over a high-level overview, because what I'm finding in our group on Facebook is that folks are joining and they're finding out about the ANC, but they're coming in on the, later chapters of the whole thing. And there's a lot of folks out there who don't understand the founding principles, the basic principles to contract law. So some of this stuff may be completely old to you guys, and some of it may be completely new, but you can't learn about something unless you know that it exists. So I'm going to go over a high-level overview. We're talking 120,000 feet here to show that there's what actually exists out there for you guys to pursue. And a lot of it is already in our group, in the files section in our group on Common Law Conversations. So this is August 11th, and this is I think the fifth meeting for the news group, Common Law Conversations on Facebook. We'll have a website soon. So here's what we're going to go over tonight. We're going to cover a high-level overview of jurisdiction, understanding contracts, the three-step administrative process, because all of that stuff is very important. Even after you get the ANC, you still have to know how to play the game, right? It doesn't do you any good to understand how to hit a home run if you don't know how to run around the bases. We're going to go over the ANC, what it is, and how, the basic use of it. And we're going to cover a couple things you guys may not have heard of in relation to the assumed name certificate. A thing called a live claim, an IRS Non-decedent Notice, courts and court procedure, and some individual station and financial planning for you as a man or woman. And by the word individual, I do not mean a fictional entity. Well, I kind of do, but it's all driven by men and women, right? You guys are just going to have to forgive me for the allergies and the runny nose. So let's start out real quick with jurisdiction. And of course, this isn't just for the 5, 6, 7, 8 people on this call. Well, not even that many right now. This is also for all the people who are going to be watching it later. So here we go. Jurisdiction. A lot of people don't know that we live in a country that has two different governments running simultaneously side by side. We have the private and we have the public. That means we have a republic and a democracy. The democracy is the public. The republic is the private. Now, before 1794, we did not have a democracy in this country. We had strictly a republic. And of course, we are trained in the schools to say the allegiance, the Pledge of Allegiance. What are we pledging allegiance to? Well, we say the republic, and then they show a United States flag, which is a war flag. Look up what the flags mean. It's a war flag. The flag that we use today is for a corporation. So the difference between the republic or private and the public and the democracy goes kind of like this. And I'm going to try to do some screen sharing real quick.
What are you looking for?
The little gray pin that I have.
You had it over here on the left, on the book.
Oh, okay. I'm going to try to do some screen sharing here. And not just screen sharing, I'm also going to do whiteboard. Let's see how whiteboard works out. All right. So I've got the whiteboard, but I also see you guys all over top of this thing. So let's see if we can remove it. We can move things out of the way here. Oh, here we go. Oh, this is good. All right. Can you all see the whiteboard? Is that popping up for anyone?
Yeah.
Okay, good deal. All right, so over here we're going to do a thing called the private. All right, hold on just a second. I'll get the hang of this. And over here, we're going to do a thing called the public. And we're going to cover this stuff quick. So you guys don't have to worry about taking notes. We're going to post this video later. Okay. So in the private, you have the republic And in the public, you have the democracy. Okay. Now, when your parents had you, they had somebody, we're just going to call this somebody John Doe. Okay. They had J-O, and this is all supposed to be lowercase except for the J, John Doe. Okay. Your mother or somebody sent off a birth certificate, and they sent it off to the public, or the democracy, and they sent back a certificate of birth. And that certificate of birth created this all caps entity called John Doe. It looks the same, but it is different. What is the same is not different, and what is different is not the same. The all caps John Doe is different than the uppercase lowercase John Doe. On the private, you have common law. In the public, you have statutes, codes, executive orders, and all the like. In the private, you have unlimited liability. Okay, that means that everything you do, you are liable for, which initially may sound bad, but it is not. In the public, you have limited liability. Someone else is liable for you. In the private, you have a allodial title, which means that you own things free and clear without the government. It means that you are all three positions of the trust. In the public, of course, you have a certificate of title or a public title, okay? And it goes on. There's a lot of differences. Now, the difference is where you're at in the trust, okay? And now that that is that way, I'm going to wipe all that out. Don't worry about clear all drawings. There we go. I'm going to show you a little bit about trust, okay? So let's say, so for trust law, okay, this is trust law right here. What have you got? You have an executor, okay? You have a trustee, and you have a beneficiary. The executor sets the policy for the trustee. The trustee acts with the property for the benefit of the beneficiary, and the beneficiary appoints the executor. That's trust law. Now, back in the day, you had shipping law. If I wanted to ship something across the Mediterranean to someone else, we needed a system where everyone could know that they were going to get their product and I was going to get paid. In shipping law, you have a ship captain. This is shipping law. Ship captain hires a crew. The crew acts with the cargo for the benefit of the cargo holder and the person who has the cargo hold. They appoint a captain. They go find a good captain to crew the ship, right? A lot of people don't know this, but there is a spot on the ship, a position when the cargo is so valuable, they would appoint that entity to look over the cargo. They would actually accompany the cargo on the ship, and their word could override the captain. But ideally, you would find a good enough captain that you wouldn't want to do that, because the purpose of the captain is to pilot the ship. Okay. Now, let's look at another form of law, and we'll call this business law. Okay. Business law, you have a CEO. CEO is the captain of the business ship, right? The CEO hires employees, and he writes policy for the employees. The employees act with the property for the benefit of the shareholders, right? Or stockholders, whichever you want to call them. And the shareholders, the board of the shareholders for the trustees for the shareholders, they can, not the board of trustees, the shareholders, they have a board. They can appoint a CEO, right? So that is business law. Now, where did all this come from? Well, it's pretty simple. If you're a Christian, if if you're a follower of Christ, you believe that all of this was started by the Father. Okay. He is the grand executor. He is the grand policymaker. Right. The beneficiary is the Son of the Father. Right. He benefits from all of this. Now, since Jesus' work on the cross, who is the Son? We are all God's sons. So the Son, of course, it would be the beneficiary or the shareholder, stockholder, whatever you want to call him. And if you read your scripture, you have a thing called the Holy Ghost. That's the trustee who does the work for God down in this realm. So your original trust law comes from scripture, hence the Old and New Testament. What is a testament? It's a contract, an old contract and a new contract. And that is the basis for trust law at 120,000 feet. Okay. If you're going to dig into trust law, what I just gave you is the blueprint for all of it. Okay. You have 3 positions in a trust. You can occupy 2 positions, but you cannot occupy 3. If you occupy 3 positions, the trust collapses. That's why they call it a trust, because you have to trust someone. Okay. Now, the next thing we're going to cover is offer and acceptance. Everything in our realm is contract, because in Eden, we needed no contract. Okay. Why? Because everything that you needed was provided. When we fell into contract. That's what we fell into. So offer and acceptance. Okay. Everything's an offer. Everything. If a cop pulls you over and says, I need to see your license and registration, that's an offer. If you go into a restaurant and the waitress says, can I bring you something to drink? That's an offer. If I say, hey, can I take you out to dinner or lunch? That's an offer. Okay. Everything is offer and acceptance. What is contract? Contract is the bringing together of parties for the purpose of conducting commerce. What is commerce? Commerce is the exchange of goods, services, ideals, energy. It's the exchange of energy. That's what it is. Now, there are 4 ways that you can handle any contractual offer. You can have silence. You can have argument. These 2 versions are dishonorable. You do not want to do either one of these, because if you are silent, I can get an agreement with you. Silence, it's called tacit acquiescence. If I look at you, if I say, hey, do you want to go to dinner? And you say yes. And I say, okay. I said, but if we go to dinner, you're going to drive and you're going to pay. So we get in your car, we go to the restaurant, you don't say a word. You agreed by your actions to those terms. That makes you a debtor. Being dishonorable makes you a debtor. Now, there are 2 ways that don't make you a debtor. One is unconditional acceptance. And unconditional acceptance would be if I looked at you and said, hey, you owe me $100. And you said, okay, Bill, here's your $100. And you opened up your purse, opened up your pocketbook, and you handed me $100. That's unconditional acceptance. Generally, that is not in your best interest. You don't want to do that. You don't want to do that. You don't want to do that. You don't want to do the silence, the argument, or the unconditional acceptance. This is where we're going to get into a thing called conditional acceptance. Conditional acceptance is quite fun. That would be me walking up to you and saying, hey, you owe me $100. And you saying, Bill, I conditionally accept your offer to pay you $100 upon proof of your claim that I owe you $100. You have 10 days to respond. That's conditional acceptance. And it doesn't even have to be overtly stated like that. I could say, hey, do you want to go to dinner? You could say, sure, if you drive and pay. That's a condition. Then I could conditionally accept your conditional acceptance. I could say, well, I agree to drive, but you got to pay. And then you could conditionally accept that conditional acceptance. You could say, well, I'm fine with that, but you pick up the tip, I'll pay, you drive. And then I say, well, that sounds good. Well, that's an unconditional acceptance of the conditional acceptance of the conditional acceptance of the conditional acceptance. So I have a document that I use called a bank fee conditional acceptance. I don't know if it's uploaded in the Common Law Conversations group on Facebook in the files, but if it is not, I will upload it after this call. And it is a conditional, it's a constructive notice of conditional acceptance for an overdraft fee. It's simple. It gives you all the elements of a written conditional acceptance, and it's pretty cool. Okay. But before we go over that, we're going to cover a couple other things too. And this is, remember, this is not to explain to you, everyone who's listening to this video or who is on this call. This is not to explain everything in great detail to folks. This is to allow folks to know what exists and what doesn't exist. Okay. Now, I got kind of an outline I'm following here. And the next thing is I'm going to try to quit sharing the whiteboard. And I'm going to bring up the camera so you should be able to see me. I would like to give you guys a couple resources that I suggest that you look into. In order to understand contract, I would advise you to get this book right here. This is Brian Blum's book on contracts, examples and explanations. He's a Harvard Law School professor. I've talked to many attorneys about this material, not just this, but like the stuff that I study. I've given courses to, hey, Ben, I've given courses to a lot of attorneys, federal attorneys that handle federal cases, trust and estate law attorneys, criminal defense attorneys, and even a prosecutor. They get 2 weeks training in contracts in law school. 2 weeks. What they don't know is that everything is contractual, everything. Okay, we say the word contract law. That's redundant and repetitive and redundant. Contract means to bring together parties. Law is agreement between men. It's the same thing. Contract law is like saying pudding. It's the same. So this is a good book. I would suggest you read it. It's laid out very well, very simply. It's an easy read. Yeah, it's a lot of pages. The writing's kind of big, but by the time you get through this book, you understand contract at a level that even most attorneys don't, because they've forgotten this stuff. Now, the next thing I would advise you to get is a law dictionary. What is law? The statutory law. There's different forms of law. You have different lawgivers. God is the biggest lawgiver. And if you are under man's law, you're not under God's law. If you're under God's law, you're not under man's law and don't need to be. But if you're going to understand what these folks are saying, you need to be on the same page. If we are contracting and I say the word person, it would be helpful if we both had the same definition. If not, there's going to be a misunderstanding. I use this, Black's Law. Black's Law is excellent. There's another one called Bouvier's. I've never used it. I love Black's Law. There's about 9 editions right now. I have found that the later editions they have more modern terms, but they're a little bit more grabbled. I used the 6th edition, which was fairly inexpensive. I think I only paid $100 for this, but it is invaluable. There are 3 books I set in my lap when I study. One is Brian Blum's book on contracts. The other is Black's Law Dictionary, and the other is this book right here. Your entire commercial world is outlaid in this book. This is the Holy Scripture, the Holy Bible. And God wrote a treatise on how to get along in a fallen world with fallen people without causing harm to yourself and others. And it is all in this book. Everything that you could figure out about contract law is in this book. You have to learn how to recognize it because the Bible is written on multiple layers like an onion. And one of those layers is definitely a legal treatise, which is why, even though this stuff is written in like 3rd grade English, it's sometimes difficult to understand because you're reading a legal book. This is a legal book, a lawful book. I mean, you could go either way with it, but it tells you all about how to get along in a fallen world. Okay. Those are the 3 books I recommend you have. Now, the next thing I would tell you is you need to understand a thing called the administrative process. Here it is. What is the administrative process? The administrative process is pretty simple, okay? It is a way to get an agreement with the other party. Yeah.
Something just happened. Mm-hmm. Yeah. I think we're not in the meeting. secured, but you're not in. You need to be in
Nope,
the-
hold on. It says that I'm still in the meeting.
It's in this window.
Here
we
we
go.
are. We're back. Did I drop off, guys?
Not for me.
Okay, good deal. For just a
We have
second,
a
it appeared
question. The
we-
first book, I typed it up there, contracts, 6th edition, Brian A. Bloom.
Yeah, and I think he's got a more later edition. Any of the editions for Brian Blum's books are good. You're going to be fine with any of them. Okay, you can get them on Amazon. They're not that expensive. Okay, the Black's Law is a little more expensive. I would recommend, if you don't have a lot of coin to spare, I would recommend you get the cheapest one you can get. The earlier the edition, better. But if you're going to go for a first edition, you're going to pay some coin for it. I've seen those things go for bucks. But, I had 2 editions. I sent one to a friend a couple years back, the ninth edition, and it was good. There's nothing wrong with any of them. As long as what you do is you reference it. When you're doing your documents and you put in a term that you want to make sure the other party understands, you reference Black's Law. Like I might say person in accordance with, Black's Law 6th edition. That way everybody's on the same page. That way you can always go back and reference the meaning of the word that you said. Okay. Now I'm going to go back to screen share. If I can without totally messing this up. Give me just a second. Here it is, whiteboard. We're going back to whiteboard, not screen share. All right, so hopefully you guys can see the whiteboard. Nope, that's not it. Hold on. See if you can help me close this out. I don't know what to click to make it close.
Well, first maybe move this and it might be in the way.
You're close whiteboard. Okay, let's do. All right, so I want to open up whiteboard. And it says new whiteboard.
Yeah.
Open and collaborate. Allow attendees to access the meeting. Is that the whiteboard that I was at a while ago?
I think so.
Screen share. Whiteboard. Oh, here it is. Okay. Excuse me, guys. I'm still learning Zoom. We'll get this crap down. Okay. So. After all that, I kind of forget what I'm going to talk about. Okay. So let's say that we have a commercial matter. Let's say you owe me. Okay. Take, for instance, a matter that I'm involved in right now. Took a vehicle back to a car lot and I put $1,000 down payment on the vehicle. Which I shouldn't have, but I was eager to try my process. So I throwed out $1,000 cash and they've not returned that $1,000 in cash, which is fine. That's fine because I have learned how to separate myself from the all caps entity. It's just business. It's no big deal. One entity owes another entity. I'm not an entity. I'm a man, so I don't worry about it too much, but I know how to get my $1,000 back. What I'm going to do is I'm going to send the other party a first notice. This is a high-level interview. This is a high-level overview. I have documents in our group that explain this on a better level and also give you explanations in the files section of the group Common Law Conversations in Facebook. And it's going over to a website soon. So I send you a first notice, okay? You guys know first notices because you get this stuff when you like bill collectors, they'll send you a notice, and then they'll send you a second notice, right? So let's say I send these guys a notice and I say, hey, you guys owe me my $1,000 back, right? And there's several elements that can go into the first notice, but we're not going to go into those just yet. Let's say they don't respond. I give them 10 days. Okay. Why 10 days? What's the 10 days? Well, you get 72 hours to respond to a contract offer. That's 3 days, right? All right. So I send off. So you get 3 days to receive the offer in the mail. You get 3 days to consider the offer. You get 3 days to send your response back. Okay, we've got to allow for the mail system to work, right? So that's 9 days. Where does the 10th day come from? Sunday is a day of rest. So that's 10 days. So we give them 10 days to respond to the contract offer. Okay. Now, we always give our brother a second chance. They may not have gotten it. They may have been busy. Something may have happened. So when they don't respond, that's acquiescence. That's acquiescence, agreement by acquiescence, right? They've gone silent. If they respond and they don't respond sufficiently, like I could send you a first notice that you owe me $1,000 and you could send me a cookie. That's an insufficient response. And we would send that back marked insufficient response. But we would give them a second notice. Okay. Now you obviously don't want to do all this paperwork for a small matter. There's ways to get around smaller matters. But for $1,000, yeah, I'll write up 2 notices because the second notice is going to be the first notice with the word second notice written on it. So I don't have to rewrite everything. I just take me a big red marker and write in at a 45-degree angle, second notice, just like the bill collectors do. You give them 10 days to respond. When they don't respond, you now have an agreement. And to ratify your agreement, to notify them of your agreement, you're going to send them a default. Now, there's different names for this. I call it, when I write up the paperwork, I call it a notice of default and dishonor. Notice of default, because they've dishonored you, right? All right. Now, once you get the notice of default out, and you should be doing this all via certified mail or registered mail, which is free for private persons. That's another class. You now have an agreement. You have an agreement, but you know people don't they don't abide by their word. So what should happen is if you get an agreement with me that I owe you $1,000, I should come pay you the $1,000. But people won't. And that's where the public court system comes into play, and that is where we will also help you understand what to do with the public court system. The public court system is your friend when you are a private person, when you're a man. Okay, so first notice, second notice, default, and then you can go to a public venue and ratify the agreement in the public, and then you've got the public on your side. And when I say the public, I mean the court system, of course. Then you can garnish someone's wages. You can lien their property. You should never place a lien against any entity until you have an agreement that they owe you and that they've damaged you by not paying you, by not making you whole. A lot of times folks want to go out and start leaning up judges and leaning up police officers and leaning up FBI agents. Do not do that unless you have an agreement with them and it is in writing. Unless, of course, you want to ruin your life, because you can do it that way. The system has to fight back if it must preserve, in order to preserve itself. And if you don't think the system won't fight back, go out and lean a judge without an agreement. You will find really quickly that every cop in the county will be pulling you over. You're going to get raided, you're going to get arrested, and you should be, because I had an FBI agent one time who asked me, he said, "Are you a sovereign citizen?" I said, "Well, those two terms are oxymorons together, so no, I don't think I am. But if you want to define that term, I'll be more than happy to tell you if I fit it. But I suspicion that I don't fit it because it's an oxymoron." He said, "Well, there's a lot of folks that will go out and lean up a judge or lean up a cop or lean up an FBI agent. Are you the type that would do that?" I said, "Well, if that judge owed me and I got a default judgment against him, would I lean a judge up? Hell yes, because he's being dishonorable and he shouldn't be a judge. So not only might I lean his property up, I'd probably also lean his bond up, because he shouldn't be a judge, because he's being dishonorable. Why else do we call him your honor? So would I lean someone up? I'll lien anyone up, any entity up, if they owe me, and I've proven that they owe me through a 3-step administrative process. So now, that is kind of the concrete foundation that we've been working on for a few years. And what comes next is the ANC, and there's some pieces of the ANC that I've not told you guys about. We call it the ANC process, but there is no ANC process. That is kind of a misnomer. The ANC is filing an assumed name certificate in accordance with your state law. It's required by law. There is no process. It's simply getting an assumed name certificate for the business name that is other than your real name for which you are doing business in the jurisdiction that you're doing business in. So when folks say, what is the ANC process? There is no ANC process, but there are some other things that can go along with this once you understand the system a little better, and we're going to cover some of those things now. So what is the ANC? The ANC is the assumed name certificate to do business with any assumed name, business name that you happen to be using. Your all caps name that is on your certificate of live birth is a business, and it is an assumed name. All of our liability comes from the fact that we're using that legal name, yet we are not registering that name in accordance with these very little known statutes, and every state has them. Unfortunately, every state grabbles their assumed name statutes to remove any power you might have by registering in that state. Now, what state has left the door open? Because they have to leave the door open in one state. I've had people say, well, what if they close the door in that state? Well, then they'll have to open it in another and we'll all be grandfathered in. However, they have to leave a door open. Satan can't drag you to hell. You have to let him. You have to go along with this. Why do you think every time you go to renew your driving license or your entity's driving license that they say, are you a U.S. citizen? Oh, sign here. Because they have to get your permission, your acquiescence, your agreement every step of the way. I went to renew my not my driving license, my entity's motor vehicle operational permit in 2016 or so. And they asked me, they said, are you a U.S. citizen? I'm like, I've had this license since I was 16. Why would you ask me that repeatedly? Because they have to continue to get our acquiescence. They have to continue to get our agreement. They have to continue for us to agree to let them lead us to hell. And that's what they're doing, because when you put yourself under man's law, you're no longer under God's law. Because what does scripture say? You can't have two masters, for you'll hate one and loathe the other, and loathe one or hate the other, vice versa. So you go and get your ANC, you're going to do it through Minnesota if you're smart, because if you do it through any other state, they're probably going to play a little trick on you where they'll say you're adopting the name or you are the business owner. You don't want to be the owner of the all caps name. You're not the owner of the all caps name. You're merely the holder. And Minnesota is the only state that lets you be the holder. And they also do it right. You don't need a bunch of proof. You don't need to file a bunch of papers every year in order to keep your assumed name certificate in good standing. You remain in good standing simply by letting them know you're still breathing, which is done with a mouse click, because 90 days before your assumed name certificate in Minnesota expires, they will send you an email and ask you if you're still alive, and you will respond with a couple mouse clicks that lets you renew it. And it's good for 10 years. At the end of 10 years, you just pay another $83 and renew it. Okay. Best $83 you ever spent for 10 years. It's only $8.30 a year. So what are some things that you need to do once you get your ANC? Well, you need to place an advertisement, an advertisement in your local newspaper. Remember all the things that used to be in the newspaper? Weddings, deaths, births, all kinds of stuff will be put in the newspaper. You need to advertise in the newspaper. If you look in the Common Law Conversations group on Facebook, I have posted a video where a gentleman walks you through how to advertise in the local newspaper. It's very simple. What's next? You should record your ANC at the county level. You'll get a book and a page number back, and that book and page number will only refer to your document. Once you record it at the county level and advertise it in the newspaper, you've got a certain amount of time. If no one objects to it, it becomes law. That means you don't have to get the assumed name certificate in the county that you're in or the state that you're in. Because the state that you're in, if you get an assumed name certificate in that state, if it's not Minnesota, they'll remove the power by tricking you into doing some things that will take away your ability to be called the holder. They'll trick you into being the owner, and you don't want to be the owner because you'll still be committing fraud. The next thing you might want to do is get it apostilled at the state level and the federal level. If you get a document apostilled, and you can look that up, it's Apostille, I think. You're getting the Secretary of State at the state level or the Secretary of State at the federal level to sign off on your document and say that's true and correct or something like that. You'll have to look it up. It's a very simple process. You'll pay a small fee to do it. Once you get something apostilled, it is good in any nation. Well, when you do it at the federal level, it's good in any nation that operates on the central banking system. So you can take this thing to Germany and use it. So if anyone on this call or listening to this call or listening to this recording is in New Zealand or Australia or Korea or Japan or Israel, then you can get a Minnesota DBA, get it apostilled at the federal level, and it's good in your country. This is international. We're all in the same system. The one world government is not only here, it's been here your entire life, unless you're over the age of like 200. What else can you do? Well, you can file a thing called a live life claim. There's a thing called the Siesta-KV Act of 1666. The Siesta-KV Act of 1666, look it up, Google it, research it. It is actually a multitude of acts that was enacted by the Pope. And I'm not going to get too deep into the whole Pope Vatican thing, Queen of England and all that good jazz, but suffice to say that we are still operating as if those things are in effect, which means they are in effect. By being in effect, these things are binding to us today, and basically you are considered lost at sea and dead. If you want to call up the Social Security Administration, if you can get them to admit your status in their system, your status is a decedent, dead. The all caps name is dead. And when you go to court, that's a resurrection ceremony. Guy's got a black robe on. Everybody says, all rise. It's a fake resurrection. You can be there in body, but if you don't admit that you're the name, if you don't pledge your body as surety for the name by saying, I am John Edward Dosen, they'll get you for failure to appear. How can you fail to appear if you're standing there in the flesh? Because you have to resurrect that dead fictional all caps entity, that first name, middle name, last name. The Siesta-KV Act says that you are dead until you notify them that you are alive. That is what a live life claim does. I will put up documents on the Common Law Conversations website, and I'll let you know how I did it and what entities you should send this thing to. There's about 9 of them. It includes the IRS. It also includes the FTC, or the Federal Trade Commission. If you get pulled over, the cop's going to run your entity through 2 databases if you give him a name, social, date of birth. He's going to run you through a state database. In Kentucky, we have a thing called LINK, or the Law Enforcement Network of Kentucky. That will let him know of any outstanding warrants or any problems or any arrests that you've had in Kentucky. Now, there's another system that he will run you through called NCIC. That's the National Crime Information Center. And as a federal agent, a former federal agent, I thought that was owned by the FBI. It is not. All crimes are commercial. All crimes are commercial. That means all crimes are private. They're upheld by private business entities. There is no common law, not in this system, not in the statutory world. So who is the highest federal entity over commerce? The Federal Trade Commission. Well, it's the State Department. Your Secretary of State is over commerce for each state, and your federal Secretary of State is over commerce for the federal government. But the Federal Trade Commission oversees those things. It's a regulatory agency, and they own the National Crime Information Center. So when you send them the documentation that you're going to learn about by following these videos and following us in Common Law Conversations and the YouTube channel, you're going to notify them that you're still alive with a live life claim. You're also going to send them something called a notice. Can we flip on the light?
And you have a question.
Okay. We're going to send them a notice to change your status from decedent to non-decedent. Okay. And that's going to go to the IRS also. And you're going to send them also a cover letter. It's called a notice to cease and desist. That notice to cease and desist lets them know that they need to stop treating you as a dead entity and stop trading that public name as if you are dead. Okay. And I'm going to upload templates for all this stuff as we go. I'm also going to let you know the entities that you need to send all this stuff to. We have them all outlined out with the addresses and the names. And as long as you're in the Common Law Conversations group on Facebook, you're going to get it. And later when we have a website, we'll upload all this stuff too. You're probably going to want to get started earlier, so we'll make sure you get the templates. Now, the notice to cease and desist, I've got a template for that. I'm not real big on templates. I think you should write your own documents, but it is good to have something to guide you, a blueprint to guide you, okay? The notice to change status from decedent to non-decedent will go to the IRS. It's 1 page. Don't worry about getting the wording. I'll upload that too, okay? So you're going to send your documentation, your live life claim. You're going to send your notice to cease and desist and your change of status to the FDIC, the Commodity Futures Trading Commission, and I'm just giving you these examples. Don't worry about writing them all down. Securities and Exchange Commission, the Northern Trust Corporation, which is actually doing business as the IRS and the bar. U.S. Department of Treasury, Office of Thrift Supervision, which is the Officer of the Control of Currency, National Credit Union Administration, the Board of Governors for the Fed. That's who that's going to go to. And an Affidavit of Life. An Affidavit of Life looks like this. Very simple, not difficult at all. No, you will not get it notarized. What can a public notary do? They can only witness a public signature. When you sign a public signature, you are signing as the owner of the all caps first, middle, last name. You don't want to do that. All you need is a couple witnesses. That's it. Now, what else we got? A lot of info, isn't it? I wanted to give an overview to let people know what exists and what doesn't exist. All right. What is your most powerful weapon? And besides knowing who you are, your most powerful weapon in this system is being able to perfect a claim. How do you perfect a claim? First notice, second notice, default. After that, if the other entity will not abide by the agreement, how do you get them to abide? Use a gun. But you don't use your gun. You use the public's gun. They have guns. They can use them. That's fine. Let them use them. Let them take care of it for you. Because once you're a creditor, they work for you. Now you combine this with ANC, it's quite powerful. Okay? Because if you file a claim, you also are facing an adversary who isn't registered. It is illegal for the clerk of court to allow that other entity to file any motion into that case. Why? Because they're going to be using the first, middle, last name. Is that name legal for them to use? Not if they ain't registered it, which means they can't file anything into that case. And if the clerk of court, who is the executor over that case and is the most powerful entity in the case, not the judge, not the state, not the prosecutor, not the defendant, the clerk of court is the executor over the case. If they allow an unregistered entity to file against a registered entity, then you should probably serve them with a notice of liability because they are harming you. They're damaging you, not harming, damaging. Okay? No, harming. Harming. You can't do a damage to a man or a woman. You can only harm them. You can damage property. You can't harm it. So, how do you learn how to function in that public world? How do you learn how to write up a motion? How do you write up a claim? A claim has certain elements to it. If it lacks any of those elements, it's no longer a valid claim. What's the judge going to do? He's got to throw it out. Okay. It's an easy way to beat a traffic ticket, by the way. Ask them to show you a valid claim. Ask the judge or the cop who wrote the ticket, if he's on the stand, ask him how many elements are in a valid claim. He won't know. Prosecutor will probably impeach him as a witness, and then there's no more witnesses. Okay. So I would suggest course called Jurisdictionary. It's great. It's like $250 to buy it. It's done by an attorney out of Florida. I bought this thing in 2012, went through it. That was back when it was on CD. I need to refresh myself on it, so I'm going to go ahead and subscribe to it again. This guy's amazing. If you
We'll
call
put a
him,
link. We'll put a link for it tonight in the group
okay, we'll put a link for Jurisdictionary tonight in the group. It is a
because we
great
bought it
course.
this week too.
Oh yeah, we've already purchased it this week too. So Courtney actually called this guy, the number that he listed, and dude answered the phone while he was standing in line at the supermarket. So maybe don't do that to him. Maybe you send him an email, but the guy cares about his clients. It is a great course. It's a great course. Now, let's talk real quick about your individual station and financial planning right after I blow my nose. You have a ship, a public ship, and you've probably not been sailing it very well. I have a public ship. I haven't been sailing it very well. It's all tattered. You need to get back in order. Scrub the deck, get all the crap off the sides, put new sails on it. How do you do that? Well, first thing I would suggest you do is you go get a bank account for your business entity, a business account, not an individual account, not a personal account, a business account. We'll be talking more about this in the group and in the videos. It's not very difficult to go get a business account. You may have to try a couple banks, but you will be okay. I learned a lot by getting my business account. I now have an account using my NC and a couple other documents that is a business account, and the business name is my all caps first, middle, last name. It's not mine, it's the government's, but it's the entity that I am a holder for. And that particular bank account does not give me any tax liability for anything put into it because there's no individual on the other side. Only individuals have tax liability. And now with the filing of the ANC, I have severed that cord. I'm no longer an individual. So I don't want a personal account. So I have a business account. What else does a business have? Well, businesses usually have a business plan, right? So you should have a business plan for your business. There are some additional things that we could probably get for our business. One of the things I'm exploring right now is a DUNS number. Businesses do not get their credit reported on a Experian Equifax TransUnion business report. That's for individuals. So I'm looking into getting a business DUNS number. DUNS is from Duns and Bradstreet. If you want to check the credit rating for any business, then that is where you go. You go to Dun and Bradstreet. You get a DUNS number, and that DUNS number is to the business like a social security number is to the individual. Okay. What are some other things? Well, once you understand this stuff, things become very simple, and all kinds of possibilities open up to you. For instance, one of the things that I recently thought about was if my first, middle, last name is a business entity, and if it is owned by the federal government, and if it is constitutionally invalid for the states to charge the federal government sales tax, then why am I getting charged sales tax when I use my first, middle, last name entity to buy something at Walmart or Rural King or Lowe's? So I got online and I looked up to see what a federal entity would do if they were to get an exemption from state sales tax. And I found a state sales tax withdrawal form or application, whatever you want to call it. Let's see if I can find it here. I may not actually have it handy.
What are you looking for?
The state sales tax exemption.
Were you showing that someone today?
Yeah, it's in a folder. It's probably up there on the table, but that's okay. We don't really need it because I'll upload this stuff later. But I'm going to apply for a state sales tax exemption number in the state that my entity is registered in, which is Kentucky. And then I would simply notify the businesses that I go to, like Lowe's. I'm on a farm, so I give a lot of business to Lowe's, and Rural King, which is it's like Walmart for farmers. And I'm going to let them know that I am state sales tax exempt, and I'll probably be given a state sales tax exemption number. We'll see what happens. I don't know what's going to happen. I'm the first person I know of, first man I ever know of to do this, right? So I'll keep you guys in tune as I do this, but there's really no reason that my business entity should be paying state sales tax. If anybody's got any good reason why I should, let me know. But if I'm separate from the business entity and the entity is owned by the federal government, then the state should not be charging the federal government business entity, which is an instrumentality of the United States, any type of sales tax. Make sense? Now we're nearing the end of our list here of the high-level overview. I'm going to upload this particular outline to the group later of what we went over. I'm also going to upload a bunch of documents over the next several days. Please be patient with me as I do so, because I have a lot of stuff going on other than this. But right now, we're just going to go ahead and go to questions. And if anybody has any questions, let me know. I think we had one other question that was already written to us.
I think you already answered it, maybe about the A and C getting it recorded first.
Yes. Should we get the ANC recorded first and then publish the local ad second with the book and page number? I'll upload the video that explains it. Anybody else have any other questions? Tell you what, you collect questions. I'm going to go grab the cell phone whose alarm is going off and smash it.
Okay, well, I think it might be yours.
It is. All good.
All right.
Can we have banks stop charging monthly fees to beneficiary bank account with ANC? Ooh, I have a bank fee conditional acceptance letter, and that bank fee conditional acceptance letter. I have a bank fee conditional acceptance letter, and it looks like this. It is for an overdraft fee, and I've used this stuff. I recently intentionally paid something late and got a late fee on that particular thing. And I did it on purpose, and I sent this stuff in and got it removed. It includes the initial conditional acceptance letter. It includes a commercial affidavit of negative averment. What is an affidavit of negative averment? And a negative averment works like this. Let's say that a police officer knocks on your door one morning and he says, hey, your neighbor Tom was found dead with a knife in his back next door. Did you kill him? Now, if you answer the question, you're doing two things. Number one, you are giving jurisdiction to the answering party. Number two, you are defending. You really shouldn't defend. So what should you do? Well, you could give a question in negative averment format. You could say, do you have any evidence that I stabbed my neighbor Tom in the back? That's negative averment. In which case you've put the burden of proof on the asking party, right? In which case they may say, well, no, we're just trying to figure out who did it. Well, if you have evidence that I did it, please come show that evidence to me. Otherwise, you have a good day. Because once you give a statement, you have to prove it. Anytime you give a statement, you have to prove it. If you're walking down the street and a cop stops you and says, what is your name? If you do not have evidence of that name on you, you better not give him a name, because he can arrest you and hold you, rightfully so, until you can prove that that's your name. So if a police officer says, what is your name? Don't just blurt a name out unless you've got evidence to prove the name. Your better answer would be a question. Well, what can I help you with today? Well, I'm trying to figure out who you are. Well, do you have evidence that I committed a crime? If not, why are you talking to me? And then I would go to two questions. Am I free to go? No. Am I being detained? And that's the only two questions I would ask at that point. Be very careful about making statements. It's okay to make a statement. If you look in John 19, when Jesus was questioned by Pontius Pilate, he made a statement, several statements, but they are eloquent. And until you hit that skill level, your best bet is to stop. This isn't Family Feud. You don't have to press a button and answer quick as possible. Stop, think, rephrase your statement as a question. We have been trained as debtors, and we've been trained to answer questions with statements, which makes us more debtors. Don't do it. Don't get tricked into it. Answer with questions. Drives them nuts too. The last thing that's a part of this commercial acceptance is a certificate of service. The certificate of service adds credence to the fact that you sent it to them. We'll also be covering how to send things in commerce without actually paying, because a private entity should not have to pay in order to engage in commerce. I have sent thousands of things with paying zero to the Postal Service. Postal Service gets paid with tax money. Love them to death. They do a great job, but I shouldn't have to pay $6.78 in order to send a response to someone who sent me an offer. We'll get this uploaded. And so the answer is, I don't like fees. I don't like, right now, Courtney's got a company that's charging her a convenience fee. What the hell is that? What is a convenience fee? Convenience fee? A convenience fee? You're charging me for something that's convenient? I'm the customer. It should be convenient.
The
How can you
convenience
charge
fee
me?
is because I went online to pay the bill and I paid with a credit card. So they just tacked on an extra fee to give me the convenience of paying with a credit card online instead of having to mail a check.
Maybe she should have to go run a gauntlet. People lined up from the company on either side with clubs in order to make it less convenient, so they won't charge her a convenience fee. But we're just going to handle that. Now, it's only like a $2.50 fee. So you may say, well, is that worth it? Hell yes, it's worth it. Absolutely, it's worth it.
Seems
If
to
it
me,
was 1 cent, it would be worth it.
seems to me it's more convenient for them, for me to pay online than for them to have to deal with a check, open mail, deal with the check, deposit the check.
I don't know what it is about my brain, but I can't understand money. Like the study of stocks and futures, how in the heck can you create a document which can be traded as a bond based on something a farmer hasn't grown yet, a future? The stuff doesn't come real well. But conditional acceptance has come great. I conditionally accept your offer to pay your convenience fee upon proof of claim that it was not more convenient for you than for me. I mean, that stuff comes easy for me. I don't know why the conditional acceptance does. I can type those things out dang near in my sleep, but I can come up with numerous conditions to place on a convenience fee. And unless they can satisfy all those conditions, then they better remove it. Because if not, then, and here's the thing about an affidavit. Affidavits are powerful. Oh, here's something I didn't cover. There are hundreds of maxims of law, hundreds. You can buy a book with all the maxims in them, and it's a great read.
It's in the car. I brought it.
Oh my gosh, that's great. So, but there are 10 maxims that we use that seem to pop up over and over and over. I have them uploaded to the group in the files section of Common Law Conversations on Facebook. And I'm going to read them real quick. There's 10 maxims. Okay. The first one I didn't really understand until later. Number 1, a workman is worthy of his hire. And if you get this off of Common Law Conversations, it has all the Bible scripture references that you can verify that this is in this book right here, the Holy Bible. All these are there. Okay. So when you read it and it says a workman is worthy of his hire, and it says the first of these is expressed in Exodus 20:15, Leviticus 19:13, Matthew 10:10, and so on. You can look them up and see them. Okay. Now they'll be worded different, and you'll have to work on understanding how that's connected to that, but I guarantee you will. The second one is equality before the law. All are equal under the law. Anytime you see the word law, interchange it with the word contract. Same thing, contract, law, contract. When you see a cop car and it says law enforcement, that's contract enforcement. Number 3, in commerce, truth is sovereign. Truth is sovereign. Number 4, truth is expressed in the form of an affidavit. The only thing that is higher than an affidavit is the word of a dying man. The ideal there is that a dying man has nothing to lose, so he's going to tell the truth. So if you come up on somebody that's taking their last breath, then their final words are actually more powerful than an affidavit. I hope you don't get to that point anytime soon. If you do, you probably won't be filing a claim. Number 4, truth is, number 5, an unrebutted affidavit stands as truth in commerce. That's why there is an affidavit of negative affirmation in that document I just showed you, because if they don't rebut your affidavit with an affidavit, then whatever they said to you is irrelevant. It's insufficient. So if you send an affidavit to somebody and they reply to you with 13 pages written by an attorney, citing all kinds of statutory codes and cases, doesn't matter. I love it when I get things back from an attorney. I've never once gotten into a rebutting affidavit back. I've handled hundreds and hundreds of matters with me, myself, other people. I have never once gotten a rebutting affidavit back. I'll spell it out for them. I'll tell them, if you want to properly respond, you have to send a rebutting affidavit, and you have to cover this point, this point, this point, this point. Imagine that. It's like the general of the opposing army saying, hey, if you want to beat me, you have to send your men to this flank, this mate, run up this many cannons here, and you can beat me. They don't do it. They never do. Why? Because in order to sign an affidavit, you have to open yourself up to personal liability, and they won't do it. Even though if you're coming from the private, especially once you've registered your name, they have no corporate immunity. There is no corporate veil. They are liable personally. They just don't know it. Number 6, an unrebutted affidavit becomes the judgment in commerce. If you have an affidavit and you do a 3-step administrative process and you go to court even without your name registered, they'll try to get you to argue. Don't do it. Stand on your affidavit. Do we not already have an agreement? Have you not already been provided with an affidavit? Have you rebutted that affidavit? And then the opposing attorney is going to try to trick you into arguing. Well, in Maxwell versus Connors in 1976, it says blah, 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 blah. Do we not already have an agreement? Have you not already been sent 2 notices and along with certificates of non-response, along with the default judgment? Did you respond to any of those with an affidavit? Do we not already have an agreement? That's all you have to do. Stand on your affidavit. Affidavits are powerful. Never sign an affidavit that is in any way untruthful. That's perjury. It's a very serious crime. Number 7, in commerce, for any matter to be resolved, it must be expressed. How many times have you had that trouble in relationships? One party's mad at the other for something they didn't say. We have to tell the other party what it takes to resolve the matter. We have to let them know that there is a matter. So this car dealership that owes me $1,000, if I don't let them know there's an issue, then how can I hold them culpable? Number 8, he who leaves the battlefield first loses by default. Commerce is a battlefield. You are on a battlefield, which would add to our resources. Read Sun Tzu's Art of War and Brian Greene's 49 Laws of Power. It will add a lot to your knowledge and wisdom. So if you leave the battlefield first, you lose. Well, think about that. If you leave a baseball game, if your team leaves during the 7th inning, you've lost. Same way with the affidavit. If you provide an affidavit and they don't, they've left the battlefield. Number 9, sacrifice is the measure of credibility. No willingness to sacrifice equals no liability, no responsibility, no authority or measure of conviction. That is why an affidavit is so powerful. If you sign an affidavit, you're doing so under penalty of perjury. You are risking your neck. You're risking prison. You're risking punishment. So if you sign an affidavit and you are the one who is holding the measure of credibility. And number 10 covers satisfaction of a lien. And you should never file a lien unless you already have an agreement and you have an invoice that has not been paid. I always give 30 days to pay a invoice. After that, as long as you have covered your bases with the written word, the first notice, second notice, notice of default, then you're good to file a lien. But in commerce, there's only a few ways that a lien can be satisfied. It can only be satisfied through rebuttal by affidavit on a point-by-point resolution, on a point-by-point basis, resolution by jury, or payment. Liens are very powerful, which is why if you start filing liens and you don't have a basis to file liens, the system will take offense. So those things will be found on Common Law Conversations.
We have one more question.
One more question. Again. How might one accomplish this while talking over the phone to an employee of the company? Well, first off, be friendly. You get more flies with honey. Number 2, anytime so I was a manager, a mid-level corporate manager for a Fortune 100 company, and I worked with a lot of employees. And one of the things I always did after I had a conversation with someone that was of any legal importance is I would always follow it up with an email, which sufficed as written communication. So if Diane came to my office and complained about someone sexually harassing her, I would then write that up into an email and send it back to her and let her know this is what we talked about, because that would confirm in written word what happened in the verbal arena. You should do the same. Verbal contracts are contracts. 90% of all contracts are unwritten. When you go into a restaurant, you sit down and you order, you've entered into a contract. Try going to the end of the meal and saying, well, you didn't give me a written contract. There is no such thing as a written contract. A contract is fluid. It has to flow. If we were all stuck to just written word, contracts couldn't flow and commerce would come to an end quickly. But the agreement that is written down on paper is not a contract. It is a memorial of the contract as it was at the time that the contract was written and signed. So people say, well, where's the contract? Well, the contract is the agreement between the parties. Does that have to be written? No. But does it lend you more credence? And is it better contracting to write down the agreement? Yes. So if you're talking to an employee of a company over the phone, you might want to get who they are, some way to contact them, you know, probably their address, as much information as you can. And then you're going to want to put that into a memorial of contract and send it to whoever has, because you don't want to deal with a lower level employee. If I walk into McDonald's and I make a contract with them using words, and they're a janitor or they're a lower level employee at the cash register, what are they lacking that I want? Fiscal responsibility. I want someone with fiscal authority, a CEO, a CFO, somebody high enough up on the totem pole that they can actually contract for on behalf of the company, and that whose word I can hold. But your lower level employees aren't going to have that. You start trying to get a claim against a company, you're going to want to be talking to somebody with fiscal authority. You're also going to want to be talking to an individual business entity. One of the things I've learned over the years is that it does no good to try to contract with a corporation. Corporations are dead entities. Corporations can't damage you. So if a cop knocks you over the head, jerks you out of the car, opens up your scalp, puts you in jail, and he does all that stuff illegally, you're going to want to press a claim against that police officer and anybody else that chooses to involve themselves in that matter. That might be that police officer's boss. It might be the chief. It might be the sheriff. It might be the attorney for the police department who contacts you. Add all these people. Earlier, I said the most power you have comes from your ability to perfect a claim and then get that claim ratified in the public. And that's what the course Jurisdictionary teaches you to do. It teaches you how to file those claims. And let's face it, until somebody shows up with a gun, people usually don't do much, right? Sometimes you get folks who are honorable and who will abide by the contract. And a lot of times you can get a company to call you up, like the lawyer will call you up, and they'll say, because they know that they're not going to stand a chance against you in court. They'll say, what will it take for us to satisfy this matter, for us to take care of this? What are you doing at that point? So if you're pressing damage claim against individuals that are inside of a corporation, and an attorney calls you up and says, how can we satisfy this? In the criminal world, when a prosecutor does that, that's called plea bargaining. So if I have a $50,000 claim against an entity, a corporation, as someone in that corporation, and the attorney's saying, what will it take to satisfy this? Will I take $35,000 to go away? Probably. Saves me from doing a lot of paperwork and I move on with my life. That's called plea bargaining. That's exactly what they do to you when you're a debtor, using the all caps name as if you own it, and you've had a charge pressed against that account. And they say, well, we've got these 5 felony charges, but, you know, are you willing to take this, and this many years of probation, this much in fines, etc., plus time served to make this matter go away so we won't have to go to court. Feds are great at this. Federal judges are masters of contract. I went up against a federal judge and beat a federal indictment. Mostly it was God's work and luck. It wasn't me. I knew just enough to be dangerous. They are good at contracting. That's why 95% of all federal cases never go to court, because people settle out of court. So hope that answers your question.
If you want, here's the list of everything covered in the jurisdiction course. If you wanted to read it.
Oh, here's the list of everything covered in the jurisdiction course. Affidavits, arguing effectively. Now, you don't want to argue. Keep in mind, this is written for debtors, okay? Court orders, filing motions, making objections, using depositions, writing pleadings, obtaining evidence, compelling evidence, filing defenses, foreclosures, family court, appeals, reading law, using stipulations, court preparations, legal research, using legal citations, claims and causes of action, show cause procedure, rules of evidence, summary judgment, default judgment, trial preparation and procedure, collecting judgment, maxims of law. That sounds familiar. Contract law. Sounds familiar. Property law. All these are the same thing. Foundations of law. Natural law principles, rules of order, and the trial of Jesus. So here's a guy who's an attorney who's teaching a public law course, and he goes over John 19. That's interesting. So that's all the stuff that's in the jurisdictionary course. So that is a cool course, man. Now, what you don't want to get tricked into is going to court as a debtor. But when you combine all the stuff that we've talked about tonight into one overview, one cohesive package, it makes you a very powerful individual, man or woman. English is a slave language. All right. Any other questions? Because we're at 9:20, which is an hour and 20 minutes, hour and 10 minutes. And that's a pretty good long time to be listening to me gab. Record all your calls and let them know as well. Helps with the follow-up email afterwards. Yep, this is being recorded and uploaded to the cloud. Takes me a little bit to get it off the cloud and process it and get it uploaded to YouTube because my internet sucks. But other than that, we're moving along pretty good.
I was just commenting on the gentleman that asked before, Ben, I think, about talking over the phone. I put an app on my phone and I just let him know I'm recording the call when I call.
Sweet. What's that app?
It's called, hold on, let me see. There's one for the iPhone, which I don't have an iPhone, I have an Android, and it's Cube ACR. It's awesome. I love it.
Cube ACR.
Yeah, Cube ACR.
I have to check it out. That's what they do
Yeah.
to us, right? Anytime we call in, they say this call is being recorded.
Yeah, and I go, is this call being, or I'll ask, is this call being recorded? And they're like, yes. I'll be like, okay, well, it is on my end too.
It changes people's behavior real quick. I have a body cam, and I have worn this body cam quite a bit, and it comes from my days in investigative work. But I don't even have to turn it on. Just having that thing on my belt changes other people's behavior. It's pretty remarkable. And I can tell you that federal agents, judges, cops, and attorneys all hate being recorded. What does that tell you? Thanks for that input. Appreciate it. And try to get more folks in on these calls. I know folks listen to the recording. I've been told of all, like I can see the views on the YouTube channel, and I'm sure all that stuff's going to go up. I'm not after views. I'm only after teaching a few people who want to learn. I wouldn't care if there's only one person on this call. And if there's nobody listening to me, I'll just record it and upload it to YouTube. But it is fun to get the backwards and forth. It makes things much easier on our end. All right. If no one has anything else, you all have a great night, and thank you for joining.
Night.
Thank you. Night, everybody.